Okay. Good evening, everybody. Good evening. Good evening. Good evening. I The phone lines will be open in probably about 30 seconds. Hope everybody's doing good. It's a little too hot.
Your show will go live in 5 seconds. 4, 3, 2, 1. Blog Talk Radio.
All right, I know I'm probably not gonna have that many people on tonight because I think Yusuf L is live right now, and some of my subscribers, they listen to Yusuf. I was about to cancel the show tonight to go and hear what he had to say, but I was like, nah, I already scheduled the show now, so I'm gonna go ahead and do it. So we're gonna talk about the child support thing. So what I'm gonna do, I'll put the number into the chat, and we're gonna read some cases. We're gonna see what's going on, and I'm gonna get inside the this ebook right here too that I got from Black Rose, the guy who wrote the book. I'm gonna get inside this too and try to explain some of this stuff to y'all. Now I don't really, I didn't go into the extensive research that he did, but I can, just read this stuff and majority of it kind of give you an understanding of what he's trying to say. But I want to read some of these cases in here. That's what I want to talk about tonight. Um, I'm thinking I'm screen sharing. I forgot I wasn't screen sharing. Hit the like button if y'all don't mind. Hit that like button. Hit that like button. Hit that like button. I'm about to go ahead and start screen sharing right now. I'm drinking my tea. I'm relaxing. Screen share right here. I'm turning the camera off and we screen sharing right now. So, y'all let me know if y'all can see the screen. Let me know if you can see the screen. The call-in number is in the title of the video. All right, that's what a call-in number at. So call in. We're gonna start reviewing some cases. This is how you do research. So, well, this is how I do my research, and I would advise y'all to just adopt some of this into y'all into the way that y'all do research. Um, so if you got a question in regard to child support, call into the show. All right, call into the show. I try to keep it at about 15 minutes per caller because I don't want to get too lengthy in the conversations, and I want to make sure everybody um who calls in gets a chance to get some insight on that question. Uh, Before I begin, let me go ahead and tell y'all it's always happen every time I go live, y'all. It never fails. Both of my, I thought I didn't know which phone it was. I got two phones, one business and one personal. All right. Before I do that, let me get into this right quick because I got to promote my channel. First off, I want to thank everybody who has subscribed to my channel. I really appreciate that. I have 2,000 and I want to say 54 or 55 subscribers. I'm respectfully asking you, if you have not already, to please join one of these. Obviously, this is $100 a month. That's too much. So I'm respectfully asking 99 cents a month. I don't even get that whole dollar. Also, once you join the juror members, you will also get access to, where is it at? These videos. Well, I got to put some more of these videos up. But this is the seminar that I got that taught me how to sue the police. And I did the research. Took me about 6 to 8 months to learn everything, but I didn't give up. And not last year, the year before last, I settled my case and I got 5 figures. I settled my federal lawsuit, but I don't want to talk about that tonight. I'm just trying to promote that. I want to stick to what's relevant for tonight, which is the child support thing. So we're gonna get into that. So The author of this book, I think it starts on page 6. Yeah. The author of this book, he titled this section "The Opposition." So he's talking about this the system's scheme to foreclose relief and the remedy. All right. And they're going to attempt, what he's saying is they're attempting to stop, to foreclose, to prevent, to bar you from this remedy that is in this ebook. That's what he's saying. And he's saying they did that by it's better if I just read it. So I'm gonna read it. I think I already have the case on the other screen pulled up. Let me check the phone lines. Y'all call in. We have. Why is it only for? I thought I scheduled it for 2 hours. I don't know why it has an hour on here, but I thought I scheduled it for 2 hours. So we only have an hour on the line. Sorry about that. But call into the show. We got an hour. Um, we're gonna get into this. Let me go back to the chat to see if I have any questions, anything like that. All right, so no questions yet. No questions yet. All right, cool, cool. All right, remember, just put your questions right here or call into the show and press 1 if you want to talk. So what he is talking about, let's go ahead and get into this. Imagine a parent's argument in court due to the court order granting visitation privileges to the parent and depriving the parent of property rights at no fault of my own. I have been deprived of the right to the custody and services of my child, property rights, which is a fundamental right, which is that is governed under another standard called strict scrutiny, and thereby relieved from the duty of support as the law of the nature deems. As the law of nature deems in my being deprived of services due to no fault of my own. That is equity. Imagine the parent seeing his child 96 hours a month and paying thousands in support, knowing full well it is unjust, it is inequitable according to the law, but the parent is now foreclosed of his or her relief, or relief from being harder to obtain due to the fact that a court or bar attorney now alleges, in its full assault to protect its trafficking scheme, that this claim to terminate a support order and go and that let me see, what is it? That this claim to terminate a support order and go back to your original status before the original granting custody is barred by res judicata and estoppel. So this is what he's going to talk about right here. He's saying that they have blurred, that they have made obscure, that they have made vague, or so to speak, or misleading the legal definition for res judicata. So he's going to give you the 1876 legal definition of res judicata, and then he's going to give you the one from 1980, which is the updated one. All right. So what does res judicata mean? It is finality, or whatever you want to call it, as to the claim or demand in controversy, concluding parties and those in privity with them, not only as to every matter offered and received to sustain or defeat the claim or demand, but as and to any other admissible matter which might have been offered for that purpose. That is the old definition. All right. Now, he says, author, res judicata's verbiage was changed, leaving a room for obscurity to take the place of the original verbiage and to drive in the foreclosure of relief after property rights were stripped away from parents. Once you read the new case reference below, think about how a bar attorney or judge, for that matter, acting as counsel for the mother, because that's what they do, with the fate of its trafficking industry on the line, stating something along the lines that father states that he was deprived of property rights in the former custody proceeding that occurred on 12/12/21, and the support order should be terminated. However, res judicata bars this action because those are claims that could have been raised in the prior court action because custody and child support was an issue. All right, but they didn't even tell the attorney who you probably hired about this. He didn't even know this. She didn't even know this. They hid this. I can guarantee y'all they knew this stuff. They knew this. Res judicata, this is the new definition, 1980. Res judicata, a final judgment on the merits of an action precludes the parties from relitigating issues that were or could have been raised in the action. Author, as one has read in the original meaning written in 1876, from which the 1980 Allen meaning derived, the could have raised provision of res judicata doctrine applies to any other admissible matter and might have been offered to defeat the claim or demand in controversy. Accordingly, the core of the parent's opposing argument is that property rights to the services and labor of the child were not a claim or demand in controversy because you didn't raise the issue. And proof of such, the only claim or demand in controversy was custody. All right, are y'all paying attention? You have to raise the issue. You have to raise the claim in order for it to be a matter in controversy. Although your right to property could have been used to defeat any notion of property rights being removed from you, which was not an issue, meaning you didn't raise it. It was not an issue, claim, or demand. It could not be used to defeat any notion of custody in the child's mother. Imagine the argument today. These rights existed, and you indeed do not deserve the pain, trauma, and wealth transfer that is ongoing, however, because you could have raised these claims after we hid them from you. Because that's exactly what they did. They knew about this because they codified this in the Social Security Act, if I'm not mistaken, that Title 4, they codified this stuff. And they just call it an absent parent. But you got to read between the lines in here. But they don't give you a definition for absent parent. Let me see. Imagine the argument today. These rights existed, and you indeed do not deserve the pain, trauma, and wealth transfer that is ongoing. However, because you could have raised these claims after we hid them from you, that you are foreclosed from relief and your claims are now barred. This is what res judicata has been set up for, and he is absolutely right. He is absolutely right. Let me get back to the chat right quick. All right, we good? All right. Let's get back. Where are we at? Where's the case? Okay. If you and the other parent were the only parties in the initial, keyword initial, custody and child support establishment action, then res judicata would not apply to a child support agency or department because they were not in privity with the mother at the time of the prior action. However, they could allege a privity based on a transfer of assignments that now acts as if the agency was in her shoes at the time of the initial child support hearing. However, an allegation is not a fact. It's not. An allegation is just an allegation. It's just a claim. You can't prove nothing with a claim unless you have evidence to support that claim. Res judicata cannot go backwards. Moreover, because no immunity can be asserted in an action filed against you by the department with you as the defendant, this is also a reason to use these hearings to then inject your motion to terminate. Otherwise, the department would claim immunity if you filed the action as plaintiff against the department. Before you do so, you need to understand the case laws and how to articulate, or your relief may be foreclosed. He is right. You're going to have to study. That's what he's telling you. You're going to have to study. You're going to have to read. Nobody can do this for you. But no attorney is going to go in there and argue this stuff for you. You're going to have to do it. Read these case laws and understand them. Res judicata does bar relitigation between the former husband and wife. All a father needs to state if the department agency alleges res judicata is that on the date your support order was entered, and the date the action was filed, the department was not in privity with the defendant. Therefore, res judicata doesn't apply. So what he's saying is all you need to do to prove that res judicata doesn't apply is to negate one of the elements that is needed uh, for res judicata to apply, because there are elements that are needed. And I think it's going to depend on where you are, but generally speaking, there's about maybe 3 to 5 elements, I'm going to say. All right. Now the next defense to learn to defeat is collateral estoppel. This is equity also, just to let y'all know. I think res judicata may be a common law affirmative defense, and I think collateral estoppel is an equity affirmative defense. I'm not really sure, but I think that's the way it is. Let me check the phone lines right quick. Oh, I got somebody on the line. All right, let me take this call.
Hey.
Good afternoon, caller.
Hello?
8588. How you doing?
Yeah, this is Gary
What's going on, Gary? How you doing?
from Iowa. Yeah, Social Security gives a definition of what they're saying about dependent child, but this goes back to 1975. They, under the 74th Congress, subsection I, Chapter 531, August 14th, 1935. When used in this title, the term dependent child means a child under the age of 16, which we know, who has been deprived of a parent support or care by reasons of death, okay? Continue absent from the home, or physical or mental incapacity of a parent. Now, a living parent don't fit that criteria. And then they go on and say, and who is living with his father's mother, grandfather, grandmother, brother, sister, stepfather, stepmother, stepbrother, stepsister, uncle, aunt, in place of residence maintained by one or more relative as his or her own home. So what they're talking about is if a parent had been locked up or died, he goes to the next of kin. What they're saying and how they say it now doesn't fit the criteria of Social Security.
So
when they give the dependent,
so
each state.
It sounds like you're saying that they are unlawfully applying the statute. Is that what you're saying?
Yeah, because each state gives their own definition.
Oh, okay, I see.
If you read,
I see what you're saying. You're right. You're right, because I was just listening to you, and I think the cases that I've litigated in Alabama, they very, very similar to what you're talking about in regards to what constitutes a dependent child. They very
right.
similar. Very similar. So
right.
I think
and
they may have adopted that because there has to be a common law definition for a dependent child, and they might have adopted it and probably added some more to it, once they codified it.
No, they took away from it.
Oh.
They codified it and took away from it, and not giving what, like passports. Passport says a person with interest with the child. Okay?
Interest is, that's
so mothers,
right, in my opinion. So
right. A father who doesn't have custody of his children has a vested interest because he's paying child support.
Yeah, he does.
So I wrote a letter to the passport people and stated everything in your own language. It states a person who has a vested interest, who is paying child support and has visitation rights, cannot be denied the right to say he doesn't want his child outside of the United States.
Sure,
no judge can order me. No judge can order me to sign anything. What they do is put the father is unreasonable, and that's what you got to look out for. They use reasonable thoughts for the mother and unreasonable thoughts for the father, saying that, oh, he just don't want to sign is not reasonable. That's unreasonable. Well, who's to say who is right unless you get a medical opinion? And they can't get it. Like you said the other night, state has to have an interest.
Yeah, they do.
And they go on and sign.
Yes, they do, yeah.
Right. They have to have an interest. How can a judge say, oh, it's in the best interest of a child to go over to the Philippines when they're chopping the heads off of children?
Man.
You gotta. I sent you a document called Essential for Attorneys and Judges in Child Support. That goes back to 1988. Okay, everybody's got to read it because it says in there what they're doing. Exactly what she said. This guy is right in what he's saying, but you have to. They wrote everything for the purpose of the mother and the state, because they say child support visitation does not go in hand in hand because it's not in the public interest. Now, what's the public interest? The government.
Yeah.
If they say the mother's not going to receive child support because she's not giving the child father rights to see his child, that's going to hurt the the state's treasury.
Yeah.
Like We Hunt versus Ledbetter.
Yeah, I see what you're saying.
I see what you're saying. We Hunt versus Ledbetter. They say it. Blissing versus Freestone. They use the word program 35 times. It's a program. I told you the other night, and you didn't call me. I got that document from 1975, how they established collection agency. It's a collection agency of the Treasury Department. That's all it is.
I'm gonna have to call you, man. I'm gonna have to call you because when I get off the phone, I be tired, man. I be so tired.
Yeah, well, you know what? I understand what you're saying because from 2013 until now, I've been reading 18 hours a day.
Whew. That's a lot.
18 hours a day, sleeping, reading, writing, doing research.
That's a lot, man.
I found documents that people don't even have. But yet, people don't want to call me. All I ask is, you say you found it by this guy gave it to, and I'm helping them. I'm helping everybody out. I could charge for this, but I'm not.
Mm-hmm.
I can even help you where to get it and how you have to apply it. It goes, child support was unconstitutional from 1935 to 1974 when Gerald Ford stepped in the office. He said it was unconstitutional. So they gave them a couple months to figure out a way to do it. And they did it by Congress. What do you think the full faith credit was about? Any state that gets appropriating funding for child support must recognize a child support order from another state. Or otherwise, they could say, go fuck yourself.
And you know what? They do that under the statute. They do they probably are required to do that independent of statute. Because of the full
Georgia.
Because of the full faith and credit clause.
Georgia took the Department of Child Support to court, and the Supreme Court said, because you are accepting child support appropriation money for the program, and again, program, you have to take the full face credit.
So they hit them with equity then. So they saying if you accepting the benefit, then you have to bear the burdens of the benefit. That's what they say.
Right.
Okay.
Also, the Interstate Family Support Act is commerce
Yes, it
over
is.
state lines.
Yes, it
It's
is.
commerce.
Yes, it is. Interstate or intrastate is commerce. As soon as I see
That's right.
and hear those words, that's the only thing that comes into my mind is commerce. They hid this stuff real
Right.
good, man. They hid this stuff so good, man. But you just gotta
Now,
you have to go ahead.
I will say, okay, one thing, and I'll let you go because I know a lot of people want to talk about it. I'm going to ask this one question. What does watches and watch movements have anything to do with child support?
You said what does what?
Watches and watch movements have anything to do with child support?
I'm not really sure. I've never been asked that question before. Watches and watch movements. Um, when you say watch, you mean like the term WATHC?
Yeah.
WATHC? Okay,
Watch,
I spelled it right.
watch, and watch movements. All right.
Um,
You
I
sitting
don't know.
down? I'll, I'll tell you. 1974, they got it out of the Virgin Islands. That's how they came out with the child support because they needed to charge for the business. So they needed to add how they are going to do collections. All businesses have a right to make money, okay, on their business. So it's actually a taxation. So what they're doing is they're using commerce, using the people and the Social Security. Watch movements. Movements. The people's move because when they closed the shops down, they went back over to the United States. So we need to keep track of them. Watch movements. You get it?
I mean
Watch
that's
and watch movements.
it's like they regulating commerce then, or interstate or interstate commerce then. If if
That's
that's
right. They regulated it into a business.
so
The collection agency.
you saying they regulated child support into a business.
Yeah, to
Okay.
charge a fee. Why
That's
do you think they make $6 billion a year?
I ain't even know that, man. I knew they made a lot of money, but I didn't even know that.
I'll tell you where. If you give me a call, I'll tell you where to find it and how to look for it, and you'll get it. And you'll read exactly what I'm saying.
All right, hold on, give me a second. So I gotta all right, I got your number. I got your number.
Okay, everybody who I tell this, they feel that they're important. They feel important, and they don't want to make these phone calls. Now I'm telling people, if you want your kids, you got to go back in the court and establish custody again. Say that you want custody, but you have to wait until a certain time because you can file custody. There's no limit, statutory limit on custody. Once a mother fucks up, you can go after custody. Like my child ran away from home. Endangerment. Okay? I could go back in the court and argue all this stuff that you had just said because this is what I'm doing.
You right.
I could bring all this back up. What you were just saying is what I'm doing in my court case. I'm bringing it all back up, and I'm saying the courts are facilitating. These are words you have to use. They are facilitating because they look for the parent who's going to facilitate the relationship between the parent and the child. If the child ran away, there must be a reason why the child ran away. And if the child doesn't want to talk to you, she has to facilitate. If the child don't want to facilitate, then you can bring her into court, but then you got to bring the fact that in that essential for attorneys and child support and that national judicial guide for judges and attorney and child support and child custody, you have to bring up the fact that it states in those that the courts do not want to arrest the mother because it's not in the best interest of the public.
I agree with that. Now, even though they have, because I've heard cases in regards to women to where they do them just as bad, but it's like they treat men just worse. That's just what it is. You know, I don't mean to sound biased or nothing like that, but that's just what it is.
Oh, it is. It's a broken down system. And and what they do is they'll tell you this is what they do. They tell you in there that they will not allow a mother to go more than 3 months if she was arrested because they lose the child support.
Well, if that's the case, then
they need to sign up.
If that's the case, I'm just making a reasonable conclusion because like I said, I haven't studied this as much as you have or the author of this ebook. But if that's the case, then they drafted this legislation one-sided.
That's exactly what they're doing. It tells you that. In those documents, it tells you. Especially when they tell you that make sure that you make it tough on the father. Make sure that when he files, you say he's a facetious litigant. Now, I went back and looked into my cases, and I found extended fraud, okay? Where the courts are doing this. They're helping the mother. They're acting as an attorney.
So you're saying it's like when they do step in like that, they title the case, I think, State X Real, and then they will have the mother's name as the complaining party, and the state will come in on her behalf or something like. It seems like that's that doctrine. What is that? Parents betrayal or something like that. That's what it seems like to me.
Yeah, parent betrayal and lacto parente.
Okay.
All right, and when they're acting as attorneys for the mother, they're actually practicing law from the bench.
Okay.
They can't do that.
They are. I mean,
without the mother going
stacked against you, man. The odds are already stacked against you because these people are. They just doing business. These people are private contractors. They are not. I mean, they officers. I see. To me, the term officer is corporate in nature. To me,
they're actually employees. That's all they are.
I can agree with that too.
Because
that would sound the same to me. But
the
reason why I call them officers is because they're acting ministerially. They're acting
right.
They're enforcing something. That's why I call them officers.
Right. But when they're doing it ministerially, they're doing it as employees of the Department of Health and Human Service and child support.
That's true.
Because if you look under the what I told you, Congressional Research Service that does the writing for the legislation, they tell you that the administrative law judges work for the Department of Children and Family, and who are they applied to? Child support. Because child support is inside the Social Security and the Health and Human Service. They don't have an oath of office. They even tell you that. ALJs do not have an oath of office.
You're talking about like the Department of Human Resources or the Child Protective Agency, something like that. Is that what you're talking about?
No, I'm talking about the ALJs do not have oath of office because they are selected from a group of applications. They take an 8-hour written. They take an 8-hour.
Go ahead. I'm sorry. Go ahead.
They take an 8-hour test and a 2-hour oral examination. So, how are they appointed? They're not elected by the people, and they're not appointed by Congress or the president. They're selected.
Yeah, I agree with that.
It tells you that.
How they do it in Alabama, based off my research, they have a circuit judge come in and sit in at the administrative family court. And once the circuit, I don't care if it was a court created by the Constitution. Once that superior court starts taking jurisdiction and exercising jurisdiction under a statute, it's an administrative agency. And that's what it is. But you can't, they hide this stuff so good because you don't know who's who, because the same administrative law judges are the same judges who the people elected to hold public office. But you don't know this stuff. They didn't separate the offices. They could whenever they wanted to, but they didn't. So they're wearing two hats. They're probably wearing more than that. You don't know who you're dealing with. But look, I got to wrap up this call because I want to keep reading about this stuff, man. I want to hold everybody up. Ugh.
But it's deep, man. And you got I spend 3-4 hours a day now. I limit it 3 to 4 hour days.
It's a lot.
And how I get my questions and answers, I ask stupid things on Google. And then it automatically gives me what I'm looking for. If I say something about child support or child custody, and I'm not meaning what I'm saying, it'll come up.
I believe it, man.
I
believe it.
I tell you, I got 1,600 documents from Yale, from all kinds of people stating the same thing. Once you read the document that I'll get you, or you get it, once you read that document, it'll fall into place.
All right, I'm gonna have to get. Well, I got your email. That's what I got your number too, but I don't want to make your number public because I don't want a lot of people who you don't want to call you. But I do have your email too. So I got you. You'll hear from me. You'll hear from me before the end of this week. You'll hear from me. I gotta work on an appeal tomorrow. Notice of appeal tomorrow.
Okay.
But you will hear from me before the end of this week because I gotta start studying this stuff just to explain it to people.
All right.
All right. Thank you, man.
Yeah.
All right. Where do we stop? Okay, collateral estoppel. I think that's where we left off at. So what I'm about to read you right now is the common law definition for collateral estoppel, and there are going to be elements in here. These elements are required in order for you to be collaterally estopped from bringing a claim. All right. Collateral estoppel, aka issue preclusion, requires 4 elements.
Well, the only parties in the initial custody and child support establishment action being read.
All right, let me get somebody else called in. All right, caller 0123. Good evening, how you doing?
Hey, what's up, bro?
What's good, man?
Ain't much. Man, I had a quick question about this. I was looking at the stuff they was using in my child support case, and they was using like 45303, and I was reading on that, and I went to 45303.15, and the way my case was, I had filed for custody before there was any child support, and she wasn't coming to no cases and stuff. So they end up giving a temporary order that said we had equal custody, and then they still was charging me the whole time, but she wasn't following the order. So then it just kept going. But my question was, like, how do I bring a case against them? Because if you read 303.15, it says that child support has to if you have a custody order, they got to help you locate your child, and they got to help enforce the custody order.
Okay, so right now you're saying that you have an order stating that custody is split between y'all two or whatever, and so I'm assuming she's not letting you see the kid or something. Would that be correct, or am I
Yeah,
wrong?
she's still not letting me see him. But no, that was the temporary order. But after going to court and child support taking the max from me the whole time and everything, I ended up losing custody in court. It was just me versus her lawyer. But I got a Rule 60 motion in right now, and I have a court date in June coming up because her attorney he didn't send none of the paperwork to the correct address. There's just so much mistakes on the custody case that they gave me another date on June, so I get to bring the custody back in the court in June.
Okay, I think I know what your
But
argument is then. So
my argument is they didn't perform. They didn't perform. If the law says right there that they gotta help me enforce, they were just charging me money, and I didn't know that they do that.
hold on. So
Yeah, this whole
what's the what's the purpose of the hearing that you have coming up?
is I have one for child. I put a Rule 60 motion, Rule 60B or something for fraud because I have a recording of the caseworker, the child support caseworker, when they first bring the case to me or whatever. I never was served. They served it to my mom's house. It's so much weird about this case.
All right, well you're let me stop you right. Let me go over this for you. What so-called state are you in? Is
I'm
it
in North Carolina.
North Carolina? Okay, so we go right now. Can you see the screen?
Now I'm on the phone with it,
Oh,
so I
okay.
can't see the. I don't know if it's gonna let me do both.
All right, well, I'm gonna just read it. North Carolina. We're gonna go to North Carolina. I'm assuming that obviously this is civil. Uh,
Yeah.
Carolina rules of civil procedure. Now they made, let me see, because they do it a little different in Alabama. So let me see if they got juvenile procedure on here. Juvenile procedure. Juvenile delinquency, North Carolina. North Carolina defines juvenile as blah blah blah. I mean it really shouldn't even I don't think it's gonna matter. So let me go back to civil procedure because it's the same thing. So you say you got a Rule 60B, and they copied it. It's very similar to the federal rule of civil procedure 60B. Okay, chapter 1A. Come on,
I think it's like a
So, all right, chapter. Let me see. Pleadings, motions, parties. Let's go down. Judgments. 60. Relief from judgment or order. Yeah. All right. So you got B. Mistakes, inadvertent, excusable neglect, newly discovered evidence, fraud, blah blah blah. Okay. Yours would be, in my opinion. This is my opinion. All right, because you were never served any of the paperwork
yeah.
as a result of them getting that order granted. I mean, as a result of them getting some motion or whatever granted before the court, right?
Yeah, and it's not in the right county. The address I was living in Charlotte at the time. The address is in one county, Hope County, and they served me for child support in Cumberland County. Now I filed for custody in Cumberland County because that's the right county where my son was before he left. And I think I had 6 months to file before they changed jurisdictions. So
Right.
I filed the case in the right county. They charged me with child support in that county, and he was gone within past 6 months. He was already a resident of Georgia.
Right. So you're saying that they didn't have jurisdiction over the case or something?
Yeah, that's what I'm saying. And then it reads in the North Carolina rules that they're supposed to bring the case in the county where the child is or where the
Yeah,
parent
that would be
resides.
venue. That would be venue. I don't really think venue is a very serious issue. They really look for
Okay.
subject matter, for real subject matter jurisdiction. Um, but in regards to your case, let's get back, focused on point, because I think you said something about they they sent some paperwork or whatever to the wrong address or something like that.
Yeah.
And as a result of that, I'm guessing a order was issued, and the order was ruled against you, and they got favor of something to that effect. Would that be correct?
Yeah. They gotta yeah, they can still gotta issue out. I'm gonna order out right now.
All
And I
right.
think it's like 580 a month, like the max amount they put me out on the max. That's another thing I was saying. The caseworker, I got her reported. She called me and said, because I filed for custody first, she said it's nothing they could do because they got to determine the custody first before they could even determine how much child support I got to pay. And then that same lady went to court and took the max amount out against me.
All right. So it sounds like you got a default judgment against you. Then would that be correct?
Yeah, default. That's what it is.
All right. Well, I don't care what it is. You still can vacate it because it was issued in a manner that's inconsistent with due process. They have to give you service. They have to serve you, unless you went down there and said, "Hey, I didn't get served," and then they served you in court, and you didn't make an objection or you didn't ask for a continuance, so you can properly prepare and answer the complaint or something like that. Then they
No,
have to.
I never been in child support court.
Oh wow. Okay, your case is really easy. Then you file a motion. It's not gonna be for fraud though. Okay, you can't really prove that they committed fraud. What you can prove is that they issued.
Not even with the voice. Not even with the voice recording.
What's the what's being said on the voice recording?
It's basically she called like right before court and she was saying, I know I previously told you there's nothing we could do. She called like the day before court that I was supposed to be in child support court. I know it's nothing we said we couldn't do, but we had talked with our attorneys and they're gonna go ahead and move the case forward. Da, 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 da. And she just basically states that she was telling me before it's nothing they could do, but they changed their mind basically.
Well, I mean, I don't think
And
that's
I
on.
need to be there.
I don't think that's on her. I don't even think that's relevant, to be honest with you. So I wouldn't even mention it. I wouldn't bring it up. I would just act like it didn't happen because I don't think it's going to get you your remedy. What you need to get
Okay.
them on a due process issue. You can void a judgment. I don't care how long it is. If it's void, it's void. So what you would do, let me see it. I wish you were looking at the computer screen so I can show you this stuff. But you did good.
I'm gonna go back and I'm
Go
gonna
ahead.
go back and watch it after.
All
So
right. You did good by filing a Rule 60B motion, but you got to do it under Rule 60B4. So you would say comes now pursuant to the North Carolina Rules of Civil Procedure, Rule 60B4, to move this court to vacate, document, whatever it is, uh, for lack of impersonum jurisdiction, because the order was issued in a manner that is inconsistent with due process. In support of these, in support of this motion, plaintiff avers the following grounds, and then you state the facts, the relevant facts proving how you were not served. All right, and then you're probably going to get a hearing on it or
okay,
something like that. If you get a hearing on it, you need to be well prepared to argue your case. I can't do this for you. I can teach you
okay,
how to. I can teach you how to draft like a professional. But
yeah,
if you can't go in there and articulate your arguments, what am I? I mean, it's just pointless of me even doing it. Don't even take the class if you're not gonna do that. This is why I tell people I can't. I mean, so what if I draft your paperwork? You don't understand it. You
yeah,
get a hearing and they get you in court and they start asking you why do you feel like this and and you can't answer it. They're not gonna rule in your favor because you're not competent. You don't even know what you're doing. But I'm not fussing at you. I'm just trying to make people understand this on why I say you have to learn this stuff. It's not my responsibility. I can teach you, but you have to go in and litigate these issues. But anytime, I don't care if they had jurisdiction when the case first started. anytime throughout the process, throughout the prosecution of any case, if they do not serve you with any evidence, they can't use the evidence. If they do not serve you any motion or any order or something like that, then they are acting contrary to due process. And anytime any order is entered in a manner that is inconsistent with due process, it is patently void. It's not even it's like it never even happened. They gonna keep going and act like it happened. I'm telling you what I know because it happened to me. They gonna keep going and acting like it ain't happened. It happened to me before until he started asking me questions, and I started answering his questions, and he shut up and he stopped asking me questions because he didn't he didn't he didn't want to talk about it no more because he knew I knew what I was talking about. Let me go. Let me check the line. Let me go back in here right quick. All right, let's get back to the
See,
where is it? I want to kind of do some research on this just to show you. I'm gonna go on case text and I'm gonna pull something up just to show you. You did right. Rule 60 is Rule 60b4. You want to be very detailed. This is void. But why is the judgment void? Because it was issued. There was an order issued in a manner that is inconsistent with due process. You entered a default judgment against me. You kept sending mail for some reason to the wrong address, and I told y'all that this is not my address. And now I get something in the mail saying, I got a child support order. I don't know when the hearing was. I was never there. I was never served with this, and this. What's going on? He who seeks equity must do equity, and he who comes into equity must do so with clean hands. I would appreciate it if y'all extended the same equity to me that I have extended to you.
okay.
Let's get where we at. We're going to case text right quick. Okay.
So I was thinking about that. What is it? Tennessee versus Pagliera. Is that relevant?
When you say attorneys can't testify and all that stuff, is that what you're talking about?
It's not. Attorney statements is not good for summary judgment because I was looking at the paperwork. She wasn't even there that day.
What?
Yeah, she wasn't in court that day. She lives in Georgia. The state did this on their own.
I
Like
don't
they
even
just
think they got
did it.
jurisdiction in that case, man. How long has she lived in Georgia?
Once I filed for custody, that's why I was saying that address thing is important because I never lived at that address. I only used that address because my mom lived there and I was living in a different city. So I'm like, damn, if I'm filing for custody, let me use the address over here. So they got that address off my custody paper. They had to. That's the only time I used that address. I never used that address.
Oh no.
Only but one time when I filled out the custody paperwork, I used the address.
Give me a second. I'm typing something in right now. I don't think they got jurisdiction. I would need to know all of the facts of the case, and that would take me some time or whatever. But you own to something. I'm telling you that right now. If what you're saying is true, I'm not saying you're lying, but if what you're telling me is true, and that judgment is void, I'm just gonna go ahead and tell you right now. They gonna act like it's right. They gonna do that. I'm telling you that now. But that judgment is void based off what you're telling me. I would need to just to be for certain. I'm gonna say right now I'm probably about maybe 95% sure that the judgment is void. If I get the facts of the case, then I can be able to determine conclusively if whether or not the judgment is void or not. But I think it's void based off what you're telling me. Civil procedures. I see judgment orders proceeding in the trial court only applies. Where is it at? North Carolina void judgment Rule 60B. Holding Rule 60B motion only apply to final judgments or orders. That's true. And this is from 1975. Let me see. Generally, a motion pursuant to Rule 60B shall be made within a reasonable time. This is the same thing it says on the federal level and in Alabama. All they're doing, it might be a little different, but it's pretty much the same thing. And it says a judgment or order rendered without an essential element such as jurisdiction or proper service of process is void because a void judgment is a legal nullity which may be attacked at any time. Every Every court around the country says this. It's the same thing around the country. Give me a second, man. I'll be right back.
Okay.
All right. Sorry about that, man.
No, it's alright.
Um, I can send you this case. Well, you'll see it in the video because there's the case. Let me highlight it
Okay.
right now. Because once you go back and look at the video, you'll see the case. I'm gonna highlight it
Okay.
right there just for everybody to see. This does not just apply in North Carolina, y'all. This is everywhere, everywhere. Let me ask you a question, man, if you don't mind. Did you draft the motion to vacate the judgment? Or did you
Yeah.
type the Rule 60B motion?
Yeah, I filed it, but that's some funny shit too. They gave me a date on the 25th of April, minute, because I put a bunch of stuff on that paper, but I've been at it for a minute. So she called me at like a couple, like 2 days ago, and said, "Oh, we can't give you that 25th date. Uh, we may need a different date." So they changed the date to May 22nd. Because when I filed it, I didn't put a date on it. I thought the clerk was supposed to give me a date. So
Did you type the
so it's
motion?
not a date on it.
Did you type the motion?
Yeah,
Okay.
yeah, but and out here you gotta have a cover sheet. That's why they denied me because I didn't even have a cover sheet. But then I was just kept reading, and they keep trying to find little things. And yeah, the last little thing is I made a mistake. I sued. I put her name and then on behalf of the child support, but it's the child support on behalf of her. So I gotta fix. That's the last thing I had to fix, and they
Okay.
give me the May 22nd.
If you're trying to vacate the judgment, you just need to put the parties named
Yeah.
in the case who were the original parties from the beginning. That would be you, probably the state.
Okay.
Then you put the title of the court. Then you put the case number, and then you type motion to vacate void judgment, something like that. And then you type comes now pursuant to Rule 60B4 of North Carolina Rule Civil Procedure, blah blah blah. Just same stuff what I said earlier. It sounds like you got a great idea. Um, I think you might need some coaching. I don't know. Maybe not. Um, so before I even try to advise you to take my course, because I don't want people to think, well, he's just trying to get some money or something like that. Now, let me show you this. Um, I have videos on here. I'm not sure if you've seen them, but they teach you how to draft motions. However, you will be limited because you won't have me. Like you may have some questions or something like that. And there's obviously questions in these videos that I didn't talk about because I didn't know people. I don't know what questions to talk. I don't know what people need to know. But let me go down. I'm gonna show you all of this. It works the same way everywhere, man. It's the same stuff. So I think I did maybe about three or four videos, maybe five, teaching you how to type a motion, how to do a motion to dismiss, how to do a motion for summary judgment. Where is how to draft a motion? Right here. So how to draft a motion.
90 seconds.
Um, I would go in when you get some time. If you're not a subscriber on my YouTube channel, just subscribe and just scroll down to videos when it says how to draft a motion, how to do a motion for summary judgment, whatever you're interested in regards to how to do a motion. Um, but
Okay.
but you're going to have to read cases. All right, you're going to have to read cases because that's how you're going to know
60 seconds.
how to argue, how to successfully argue your case. I think that judgment is void. I think that judgment is void. And you can vacate a default judgment due to lack of imperfection service process. If they didn't serve you, it's void.
Okay.
Uh,
Okay.
oh, and back in regards to your question about Trinsley versus Pagliera or whatever you want to call it, I did a video on that, and I think you're gonna like it.
Okay.
I did a video on it on my YouTube channel. It's called Trinsley versus Pagliero, and in the video,
Okay.
if you go and watch that video, you're gonna be like, okay, so this does not just apply in Pennsylvania.
10 seconds.
This is a principle. It applies everywhere. And that's exactly what it does. It applies everywhere. You need to go and watch that video. I did that video over a year ago. Nobody can testify unless they're a witness. Or unless you don't object.
Yeah, that's what I'm saying. What kind of proceeding did they have? I mean, hold
You
if
don't
she
know. You
wasn't
weren't
there,
there.
and
You
if
weren't there. You see what I'm saying? You don't know.
but I'm saying if she wasn't there, if she can't, and nobody was there to validate anything, it's just child support turning in there.
They got if they got a default judgment against you, it don't matter. But you still can go and void it because you were never served.
Okay.
You can even if at your hearing, if you get it wrong, you still can bring the issue back because if you didn't properly raise it or something like that, you can bring it back. But if I were you, I would make sure I argue this my first time correct because you can't keep filing rule 60B motions to vacate a judgment on the same facts and issues. You can't do that. That's a principle. There's actually case law on that. So if you want to make sure you get it right, when is your hearing? Next month or is it this month?
It's May 22nd.
May 22nd. All right. Well, I tell you what. This is strictly optional. This is just my advice to you. At least, give yourself maybe not too much time, but give yourself maybe a week. I think 2 weeks you might be pushing it. I would give myself a week to see if you want to try to do it by yourself or to see if you need help. If you need help, this is just my advice to you. You don't have to do this. If you need help, you should, let me go to my community section on my YouTube channel. You should register for my draft class next month. Let me read you the instructions.
Okay.
The class is $200. It's going to be a 6-day course, 18 hours. It's only 10 people because I can't deal with more than that because I don't feel like it's going to be beneficial. So in other words, I'm more so of a quality over quantity type guy. I really want to make sure that y'all are getting this stuff. So let me read this to you, and everybody else, if you haven't, whatever, let me read it to you. If you want to attend draft class next month, send a $50 deposit via Cash App, Zelle, or PayPal, plus the transaction fee, and then email me. Once the deposit is made, I will email you a registration link. The deadline for full payment is May 18th, 2024 at 11:59 p.m. Central Standard Time. All right. And I understand if you probably don't, you probably never seen any of my paperwork before. I could be a scammer or something like that. And I completely understand because there are people online who will scam you and block you and lie on you and say you didn't send them nothing. And so I get it. I get it. So it's strictly optional. But I think you should just
Okay.
give it about a week and just study, and read cases and read cases that are factually similar to yours and ask yourself, okay, well, since I was never served, what does the law say that you're supposed to do when somebody files a motion to vacate due to lack of insufficiency of service? What does the law say that they have to do? And go read those cases. That's going to give you a better understanding, in my opinion. That's what I had to do. But when I tell you all of it, it is easy, fam. It's easy.
Yeah. I mean, what do you do when they just don't listen? Because I feel like in custody, it's the case in North Carolina that man, it pretty much shuts down parental alienation. It's called Dean versus Dean in North Carolina, but in that case, the mother had took the child away from the father, kept him away for a year, and the court ruled that if a parent severs the connection with another parent, that they're not acting in the best interest of the child, and and she lost
They
custody
right.
in that case.
They right, but that's also what happens is did you did I send you a copy of the Treaties of Roles and the Child Support Remedy, those ebooks?
Oh yeah, yeah, I got those ones. I
Okay, yeah,
think.
you need to
Well,
you need to read those when you get some time. I know they're probably a little difficult to read because this stuff may be new for you, but you need to read those books. But yeah, and she's depriving you of essentially due process, but she can't. I mean, she can't violate the Constitution. The Constitution doesn't apply to her, and a lot of people don't know this. What I'm about to say, I don't see how, but some people just don't know it. You do not need to go to court and petition for custody because you already have it. Like you
that's
have
another
this,
argument I was making in there.
yeah, you have
That's
this
another argument I
unconstitutional.
was making in there.
Yeah, these are fundamental rights though, but people they just some people they just don't know they don't know how to act. They don't know how to act, and they run down to these administrative agencies thinking they finna get some justice or whatever, and that is the worst thing you can do, in my opinion. That's like a last resort type thing for me, and I probably still wouldn't do it as a last resort because I'm extremely private. I value my privacy and I value my kids' privacy and the mother of my
Yeah.
kids. You know, I don't got time for all that. I don't have time for that. But
So what do you think about the tort law?
in regards to what
Filing a tort claim.
against who?
Them being child support being like working for the state and the
You could I would have to see the statute. You know, I got to read the statute, and I need to read some cases on the statute to see what they're saying about it before I can give you an answer. Because right now I wouldn't even be able to tell you. But I'm pretty sure that they're probably going to
okay.
claim some sort of immunity or something like that. If not, like I would just need to read the statute and cases on, preferably
Yeah.
the cases because the statutes sometimes they just too vague for me.
It's saying though in North Carolina the state has insurance, and if there was a duty, that's why I asked you about that 303.15, because in my case they didn't enforce, they didn't help me look for them. They just was charging me money, and they knew I didn't know
Oh,
where he
okay.
was
So
at.
you're saying that I guess their failure to do something is a tort. I mean, that sounds like
The
yeah,
negligence.
negligence. That sounds like some negligence to me. I don't know. I would have to read it, man. I don't want to give you
And
no.
it's just
Go ahead.
it's crazy because that's the law they use. They use 303, 45, 3030 to take your money. That's the law they use. It's on the paperwork they use to take the money. But if you read the actual 45, 303.15, it say that they're supposed to help you. So that's what I'm saying. How can they use one part of the law but not the other part?
Well, they do that because you allow them to do that. Because you don't know how to. You probably don't know how to. I'm just guessing. You don't know how to articulate your case. So in exchange for these, in exchange for their protection, it sounds like that you have to pay them, and you were paying them, but they're not helping you enforce your rights, whatever you want to call it. So they're in breach of their what is that fiduciary duty, something like that's what it
Judiciary.
seems like to me.
Yeah.
That's what it seems like to me. Um, oh boy, these folks they get on my nerves, man. These people get on my nerves. They get on my damn nerves, man. Uh, I mean that's the best I can advice that I can give you right now. But back to your
Okay.
case, I think you got a good case, and I really do think that you can get the judgment vacated, depending on how, if you got a fair and impartial so-called judge, I don't see why you couldn't get it vacated. But because you're pro se, they just hate pro se litigants. They just hate, especially if you know what you're doing. If you know what you're doing, they hate us. They hate us. They might send you through an appeal. Now you got to appeal the case. But if I was you, if that happened, just raise the same exact argument, because that's what they did to me. That's what I'm going through right now. They never want to tell me I'm wrong. They'll just deny it without any reason. No case law, no nothing, just deny
Okay.
it.
That's a mind game.
Yeah, they know I know I'm right. I don't care who it is. There is no so-called judge that can sit on any bench and tell me I'm wrong about my paperwork, because this ain't my argument. These are y'all arguments. This is what y'all are saying. So you saying that your colleagues are
Yeah.
wrong? All I'm doing is repeating what they're saying. That's it. That's all. That's all of us. All of us are doing is repeating what's being said. How long have I been on here? Almost 2. I don't even know. Let me see.
Yeah, but I'm gonna let you go, but I gotta grab something to eat and shit. But yeah, I definitely appreciate that, bro. And I'm gonna watch your video back so I can see about the class and everything.
Okay. Well, the class is you can go in the community. I don't know if you're a subscriber on my channel, but you can go in the community section on my YouTube channel and just scroll down. I mean, you can go back and you'll see cases that'll just blow your mind, because I just read cases, and if I see something interesting, I just copy and paste it onto my YouTube channel for people to read for themselves. But
Okay.
yeah, let me go back. I got to get ready to get off here. I'm staying on here longer than I anticipated, and I'm getting a little off track. But thank you for calling in, and just study. I will give it by another week. I'll give it about another week. Don't wait too long.
Okay.
All right. The class
But
it'll be 3 days a week: Monday, Wednesday, and Friday, 7 p.m. to 10 p.m. Monday, Wednesday, and Friday. We're gonna do it twice. So 3 times one week, then 3 times another week, same time, same hours, all that stuff like that. 10 people. I only want 10, so it's a timely situation. It's a timely situation. But if it's something that I feel like that I just need to do, like I have to just do it every 2 weeks or whatever, then I'll do that, and I just take another new 10 people or whatever, and we'll just keep doing it like that.
okay. Yeah. But definitely, I appreciate it, bro.
No problem, man. Good luck.
Uh,
All right. Okay. Let me get back. Let me go check the chat. I don't know what's happening, what's being said or nothing. What am I doing? How do I? Oh, right here. All right. Sorry about that, y'all. Waiting on it to load up. Let me check the chat. Okay. All right. My child support modification court date is coming up, and they have set in 900. That's crazy, a month, which is not bad. But what can I do? It's out of California. Well, it. I wish you would have called in. I wish you would have called in, Mr. Ray's. Um, yeah, it depends, man. I would need to see, maybe if there was a due process violation, you can get it vacated. Um, you probably still can get it vacated because they deprived you. Well, it is a due process violation. Matter of fact, let me go back to this document. Because if y'all are still watching, it starts on page 6. He's discussing your remedy. The author of this ebook, he's discussing your remedy. How do you get your remedy? But if you cannot understand this stuff, I don't know what to tell you. You're gonna have to read it until you understand it. Do not give up on it. Don't give up on it. So let me. There's a case I wanted to this case right here. All right. If you don't have this ebook, let me just go ahead and read this for you. When a man abandons, I want y'all to pay attention to this now, because when I read this allows me to reasonably conclude that they knew about this and that they actually they codified this. They brought it over from the jurisdiction of common law into their jurisdiction, and they modified it a little bit. This principle right here, because this is a principle. When a man abandons his child and casts it upon the public, aka government, he becomes liable for its support. But it is entirely impossible to treat a child as thus cast upon the government, when fact simply is the mother has deserted the father and carried away the child and continues to support it. We're doing equity here. So I went and see if I can. I went to case text to see if I can actually find this case, to see if it was on case text. It's not on case text. They do. There are some cases that do cite it right here, because this is the case right here. See this, Ramsey versus Ramsey, Illinois, volume 121, page 215. Let's go back just to show y'all that that's the correct case. 121, Illinois 215, Supreme Court, Illinois, 1889. Right here. Let me see. And they were talking about this a long time ago. Let me see. Of course, the case. Let me see. Let me see. Let me read this right here. The plaintiff's claims that as the divorce was granted upon a publication, and the court had no right or power to decree the support of the children in personam against the husband, his rights are precisely the same as if no provision had been made for the custody of the children. While the defendant claims first that the plaintiff's right, if any, must be asserted in the original equity proceeding, or that if she originally had any remedy at law, she is stopped from asserting it by reason of that portion of the decree awarding custody of the mother. Of course, the various cases cited by the plaintiff, the only one almost precisely like the one at bar is what is this? Pretzinger versus Pretzinger, supra recovery at law, where the decree awarded the custody of the children to the wife. But these are based on the doctrine of equitable the doctrine of estoppel, as husband and husband, Illinois, and Ramsey, blah blah blah. And some hold that where the father has been deprived of their custody in society without any fault on his own, he is not liable. This they've been new about this stuff, man. These are all the same cases that are agreeing with this principle right here, what I just highlighted. But these cases, you can't click on them. All right. So when you're on case text, anytime this happens and you on case text, this is what you need to do. You're gonna go to case. Yeah, right. Case.law. All right. And you go to Illinois. Where's Illinois at? I mean Indiana. Was it Indiana? I think it was in. Let me see where. I think it was Illinois or Indiana. What is it? Okay, it was Indiana. You go to Indiana. Where we at? That's Illinois. Where's Indiana? You click on Indiana. All right, and you click on right here, Indiana reports. These are Supreme Court decisions in Indiana. All right, they start at 1848 and they go all the way to 1981. And if you go back, Blackfoot, I'm not sure what that is, but they go as early as 1817 to 1848. All right, this is how you learn your cases. All right, so we're gonna go to, what volume was that again? I think it was 121. Okay, we're gonna go to volume 121. All right, this is how I do my research. There's it right there, volume 121. You click on that. What is this? Bulk data, case, metadata. Let me see if we can get it like that. Okay, that's not it. Scan PDF. Is it on here? They got the whole. Okay, so they have this whole volume right now. This whole volume, 121, in a PDF file. It is 680 pages. All right, that page number was, I think it was 215. Yeah, it's 215. So what we gonna do? We're going to go down, table of contents. We're going to go all the way down to 215. That's what we're going to do. And the case is going to be right there. There it is right there. Boom, right there. And what do you see? Ramsey versus Ramsey. I don't know how long the case is. Let me see how long it is. 215. Ramsey. Okay, so it looks like the case probably maybe about 6 or 7 pages, something like that. Well, probably about 8 pages. Yeah, I would say it's about 8 pages. All right, and that's what you do. And you read this case. That's what you do because they got this principle from there. That's how I do my research. 1889, they been knew about this stuff, man. This is our fault. Ignorance of the law is no excuse. Everybody is presumed to know the law. That's how these people construe this stuff. I wanted to actually read this case, but I'm a little over my time limit right now. Let me see what this says though. After a decree of divorce, either with or without an order from the custody of the children, there is no implied obligation on the part of the father to pay for support voluntarily furnished by the mother of the child, by the mother of the children, while she asserts and maintains the right to their custody and society, unless the father has in some way manifested his purpose to abandon them, or he has refused to take them into his custody and render them a proper support. This is the same thing that this author is talking about in Treaties of Rose. This is the same author right here. This ebook right here, the same author wrote this ebook right here and rendered them a proper support. Where is it at? I think this is it. Yeah, this is it right here. Render them a proper support. This is it right here. He's done his research. This is how you get these people. You have to go back and see what they did. You got to go back in time. There it is right there. 1889 Supreme Court case of Ramsey seeking a natural and natural law and 2 distinct acts of a parent that would fit the definition of an absent parent in it stating the father has in some way manifested his purpose to abandon their children or to refuse to take them into his custody and render them a proper support. Look at this, man. I can do this all day, y'all, but I mean, what's the purpose of me doing it if you can't put it on paper and argue it for yourself? You're gonna have to argue this stuff for yourself. I can't do it for you. Only thing I can do, I can guide you and I can tell you how to argue the cases, how to draft the paperwork. But you got to argue this stuff yourself. Let me go back in here. To answer your question, Mr. Reyes, I forgot, but I would need to know the facts of your case, man. I don't think I can answer the question unless I know the facts of your case. And I would need to know the facts of your case. I don't really have time to litigate it right now. But to everybody, this is for everybody who is having issues in regards to child support. All right. If you do not know how to do the paperwork, you need to either watch my videos that teach you how to draft motions. I did about 3 to maybe 4, maybe 5 videos to teach you this stuff. Okay. And if that video, if you don't think that that's enough, or if it's beneficial, then you need to register for my draft class. All right, send me $50. I just read it in the video. Send me $50 to reserve your spot or whatever, and then you can send the other $150. You make installment payments, whatever you got to do. Okay, whatever you got to do. And in this seminar, this webinar, whatever you want to call it, we're gonna go over this stuff. Any questions that you have, any examples that I got to do to show you, whatever it is to get you to understand this stuff, that's what I'm gonna do. Oh boy, I got a headache. Where is it? Where is this case at? Right here. This man did his research. He found this case. Now, if you don't, If you don't want to, do this online, you can go into a law library and get this stuff. You can go on the law library and look this case up the same exact way that I did, but you can get it out in a book off the shelf. All right. But look, y'all, I'm tired, man. I got to get up out of here. I'm tired. I got a headache, getting on my nerves, and I'm thirsty. All right, that's it, y'all. I'm gonna get on up out of here. Hopefully that helped y'all. Um, let me read. Let me read some of these comments. I'm sorry. I don't want y'all to think I'm ignoring your comments. Rico. To see if you can even use the recording that was obtained without her knowledge, I'm sure. Yeah, that's probably a good point right there, perspective. If you want a good example of what you're up against arguing with these people, listen to this brother out of Florida and how they completely disregard their own. Boy, they will do it. They sure will do it, especially if you right. Especially if you right, they will do it. That's what they do. They do it to me, but I just, I already know I'm not gonna win in there. Let me just file this appeal. I think I have a better chance on an appeal at beating these people. So that's what I do. I just make a record, get all my stuff on the record, and I just appeal it. I don't have time for this. All right, look, that'll be the end. I'm out. I'm tired. Everybody enjoy your evening. The Supreme Litigant is out. Peace.